call the meeting of the Interim Joint Committee on the Judiciary to order. Mr. Clerk, you please call our roll.
Senator Carroll, Senator Janine, Senator Neal, Senator Nemes,
Present.
Senator Reed, Senator Stivers, Senator Thomas, Senator Wheeler, Representative Banta, Representative Bauman, Representative Blanton, Representative Burke,
Here.
Representative Decker,
Present.
Representative Dietz, Representative Flannery, Representative Griffey,
Here.
Representative Kulkarni,
Present.
Representative Chris Lewis, Representative Derek Lewis,
Here.
Representative Maddox, Representative Marzian, Representative Moser, Representative Nemes, Representative Petrie,
Here.
Representative Roberts, Representative Stevenson, Representative Whitaker, Representative Williams, Representative Wilson, Co-Chair Storm,
Here.
Co-Chair Elliott.
I am here. So the second item is approval of the minutes of the June 10th, 2025 meeting. Is there a motion to approve the minutes? There's a motion. Is there a second? All those in favor, please say aye. Aye. And the minutes are approved. So the third item is Angela's Law, and that will be the first matter that we take up today in the 24th session. That was House Bill 198, and that was an act relating to aggravated circumstances sponsored by Representative Heverin. And I see that she's here and she has some guests. And if you would all introduce yourselves and then proceed. And good morning. Good morning, importantly, right? Good morning.
Good morning. Thank you all for having us, Chairman Elliott. I am Samara Heverin. I represent the 18th District, which includes all of Grayson County and a portion of Hardin County.
I'm Doug Kerr.
I'm Angela Kerr.
Doug and Angela are my constituents, and so we are here today to talk about Angela's Law. One of the best parts about being a state representative is getting to represent your people. That's exactly why we're here to serve. And whenever families bring specific laws to us, I think it's important for us to advocate for those and talk about them. So I really appreciate the opportunity to be here today to share about Angela's Law. I want to talk a little bit about what Angela's Law does, how we got there, and then I'm going to let Doug and Angie speak and share anything that they would want to. So in Angela's Law, in cases where the death penalty may be authorized, this law would add the following to the list of aggravating circumstances for the judge and jury to consider. The offender abused the corpse of the victim of kidnapping or murder by engaging in deviant sexual intercourse, or sexual contact, as defined by KRS 510.010. So Doug and Angie's daughter, Angela, was murdered. And Angela is a year younger than me in school, and I think any life taken before natural death is way too soon. And so I appreciate them having the courage to be here to advocate today for Angela's Law. So a little bit about the Angela's murderer. I don't want to say his name because I don't think he deserves to be talked about, but I do want to talk about the specifics of the case. He was first arrested for as a juvenile for various offenses. When he was 19 years old, he committed burglary. I don't know. I can't say that. Y'all get it. I'm a little nervous, apparently, Chairman Elliott.
I can't say digitization, so I understand.
Thank you.
I understand how that can be.
In the second degree, in theft by unlawful taking over $300. The offense date was January to February 2008, and a total of a 6-year sentence. When he was 20 years old, he was charged with robbery in the first degree, and he received a 10-year sentence. He was sentenced to prison after both of those offenses, and he basically spent the entirety of his 20s in prison. He was released on January 5th, 2021. The offense that he committed was between March 11th and March 12th of 2021, 2 months after his release. He was 31 years old. He has spent approximately 1 year of his adult life out of prison. When he is approximately 51 years old, he will again have a chance to be paroled. In this case, He was charged with murder, abuse of a corpse, possession of a handgun by a convicted felon, and persistent felony offender in the first degree. He did not qualify for life without parole or the death penalty, even though there's a recording of him, recorded by him on his cell phone, of having sexual intercourse with the victim's body after the murder. Because she was deceased, it does not qualify as rape as an aggravating circumstance. A jury convicted the defendant of all charges and gave him 70 years. Regardless of the number of years, the defendant will be parole eligible after his service of 20 years. The victim's family in this case, given the defendant's prior history and the horrific nature of what occurred to their daughter Angela, believe that he did not deserve the opportunity for parole or to see the light of day at the age of 51. The only way to make that possible would be if he was given life without parole or death, again, not an option available to them because he had had sex with the victim after death, not before. Adding an aggravating circumstance does not require that option to be exercised, but merely puts more tools in the toolbox. I'm not saying that the judge has to do this. It should just be another option for them to look at whenever an instance like this comes up. While this is just one case, it doesn't mean it's not going to happen again in the Commonwealth of Kentucky. Doug and Angela, do you all have anything to add?
Yeah. On March 12, 2021, I received a phone call my daughter had been murdered. Had to go home and tell her 5-year-old, 3-year-old great-grandkids. Pretty horrific. Never knew abuse of a corpse. I thought maybe the body had been moved. I found out through the news enterprise of local media that she was found laying halfway in and out of the house naked. Teresa Logston, weeks later, pulled us into her office to tell us. And there's never such a terrible thing to have to be told that your daughter was murdered and then taped having sex with her. And for them to tell me a sentence maximum of 5 years was just terrible. That's the sole purpose to me of a father, is to protect your family, your kids, your wife. And I just hope that we can do something different. So if anybody else has to go through what me and my wife and children have, that they won't have to suffer as bad. At least they would know that he did get more time. And I just don't see that he's an animal. I didn't realize people could be so horrific, and it's sickening to me. And I thank you for listening to me, and I appreciate it.
I agree with my husband. It was terrible. And as Samara said, his prior, he got 6 years for robbery. But he committed sex with her after she died, and she's not considered human. I don't think that's right. She's still human to us, even today. So we do think that law needs to be changed. And I appreciate you all listening too.
Well, thank you for your courage in coming forward, and you certainly have my sympathy and the sympathy of the committee. That's just a horrible thing that happened, but you're trying to make a difference through it, and I think that's the important thing here. Is there any discussion that any member may have? Senator Wheeler.
Thank you, Mr. Chairman, and I can't imagine what you all are going through, and that's one of the most horrific things I've ever heard in my life. It's a shame, frankly, that somebody with a recording like that you can't just haul them right out of the courthouse and let everybody know what you should do with somebody like that and make them no longer of this world. I hope and pray. I think, Samara, this is a good bill. This really lets the public know that in the Commonwealth we stand for law and order, and we're not going to tolerate animals like this within our society. And I think that if anything, if we can try to expedite the punishment of criminals in the maximum way in cases like this, I would think that we should try to move forward with additional legislation to make sure that people like this get to hell a lot quicker than what they're going.
Thank you, Senator. At one point, I know that I had a constituent who had gone through something similar. Unfortunately, not as horrific as what you all have gone through. But at that point in time, the state punished the abuse of a corpse as a misdemeanor. And so I had a bill that made that a Class D felony. And my bill didn't get through the process. A Senate bill did, which then made the abuse of a corpse a Class D felony. Because at that point in time, I didn't think we took this seriously enough as well. So I'm grateful for your testimony today. I think it's been informative, and you have our prayers and condolences. Thank you, Representative Heverin. I'm sorry, Representative Petrie, you're recognized.
Thank you, Mr. Chairman, and I'm so sorry, and it's about there's nothing to say. As to trying to address it statutorily, don't need a response, but I would also make sure that if you're going to seek modifications, also think about whether there would be a modification that clarifies whether this is specific to the offender who is kidnapping or murdering, or it could also apply to if there are multiple persons involved in varying degrees in a kidnapping or murder, but not all engaged in the same behaviors. I would want to make sure that statutory changes are not too narrow and wouldn't catch a co-conspirator of some degree. Thank you.
Thank you, Chairman Petrie. And I think that's all. Is that all we have at this point? Okay. Thank you again. Thank you, Representative Heverin.
Thank you, Mr. Chairman. We're honored that you would share this story, and I just really appreciate the Kerrs having the courage to come up here and share this in Frankfurt. Angela, like I said, was a year younger than me. I actually grew up with Angie's daughters, Erica and Tiffany and Natasha, playing volleyball, and this is we're a really close-knit community, and when one hurts, all of us hurt. And so, thank you for the opportunity to present today.
You're very welcome.
Thank you.
KRS Chapter 202C, and we have several presenters for that. If you would please come forward, and you'll be recognized, and if you'd introduce yourself, and then you can proceed.
I'm Judge Lisa Payne-Jones. I am with the Kentucky Court of Appeals representing the First Appellate District.
And I'm Shauna Mitchell, the Administrator for the Kentucky Judicial Commission on Mental Health.
All right, thank you. We'll see. Is my microphone working now? All right. So thank you for the opportunity to be here this morning to present. Attorney General Coleman's really prioritized zealous collaboration, and we just really appreciate the opportunity to be here to speak about KRS Chapter 202C this morning. So I personally have had the opportunity to work on a case under 202C. I have been on that case since the filing of the petition for 202C, through the evidentiary hearing, the commitment hearing, and now we're in the commitment review hearing stages. That may mean nothing to any of you at this point. If you have been serving for quite some time, you may be very familiar with 202C. However, if you're a newer member, you may not have quite as much familiarity. So my hope is to provide an overview of 202C today, that by the end, we'll at least all know what cases fall under 202C, what the different proceedings in that process look like. All right, just a little bit of history about KRS 202C. It initially became effective on April 1st of 2021, and the purpose was to close a loophole that had been identified in KRS Chapters 202A and 202B. 202A and 202B govern involuntary civil commitment, so they were obviously in existence prior to 202C. Now, 202A addresses individuals with mental illness and how they can be involuntarily committed. And 202A.026 sets forth the criteria for when an individual with a mental illness can be involuntarily committed. Now, I have all 3 criteria on the slide. I will not read all 3 to you, but I would like to highlight criteria number 2. It's whether or not that individual can reasonably benefit from treatment. And so you will see that again in KRS Chapter 202B, which addresses involuntary commitment for individuals with intellectual disabilities. So the factors or criteria that must be met under 202B are set forth under 202B.040. Here there are 4 criteria that must be met for involuntary commitment. All 4 of these criteria must be satisfied for commitment to occur under this statute. And again, I draw your attention to criteria number 4 here. We see the same language that in order for involuntary commitment to occur, the person has to reasonably benefit from treatment. So what was identified was that there were individuals, specifically people who had committed really heinous, very serious criminal offenses, who were suffering from either mental illness or laboring under an intellectual disability. They were arrested for the offense that they committed. They were charged, the criminal process began, and competency was raised. So then a competency hearing was held before the court, and these individuals were found not competent to stand trial, which then, prior to 202C, left us only with the option of 202A and 202B for this individual to be involuntarily committed. However, there were some people who were suffering to such an extent that even with treatment under 202A or 202B, they weren't benefiting from that treatment. So if they're not competent to be tried through the criminal process, and they can't be involuntarily committed under 202A or 202B, then they were ultimately being released back into the community, posing a threat to themselves as well as to the community at large. So the legislature acted, and 202C was enacted. Now, not every person who commits a crime and is found not competent to stand trial and can't be committed under 202A or 202B is going to fall under 202C. We are just talking about the most serious of offenders here. So you have to first have a finding that that person is not competent to stand trial. And then second, you have to have a qualifying offense. So specifically what satisfies as a qualifying offense is in KRS 202C.010, subsection 12. We're talking about a capital offense, a Class A felony, a Class B felony resulting in death or serious physical injury, so not just any Class B felony, those specifically Class B felonies with death or serious physical injury, or a violation of KRS 510.040, rape first, or 510.070, sodomy in first degree. So those are the offenses that can bring an offender under 202C. If this happens, the Commonwealth's Attorney's Office in that jurisdiction where the offense was committed then has the responsibility to immediately file a petition under 202C. So I'd like to give a little bit of context of what this looks like. So let's say we have someone who committed a murder, but that individual, because of either mental illness or intellectual disability, is not competent to stand trial. They can't go through the criminal process. Therefore, they have been found not competent to stand trial. They've committed a qualifying offense. We're talking about a murder. They would be under 202C. So the Commonwealth Attorney's Office, who has been prosecuting that murder case, then has the responsibility of filing a petition under 202C to start the 202C proceedings. Once that is done, we proceed with the evidentiary hearing and commitment hearing, which I'll talk about here in a moment. Once the petition is filed, the court then has a responsibility to assign a guardian ad litem to represent the needs and best interest of the respondent, and this is not a replacement for the defense attorney. So a respondent going through 202C proceedings has both a guardian ad litem as well as a defense attorney representing them. Now, do note the use of respondent here. Obviously, if we're going through a criminal proceeding, we're referring to the charged individual as a defendant. Under 202C, we're talking about a commitment proceeding, so we are referring to this individual as a respondent. I am primarily a career prosecutor. I told you I've had a case under 202C. I cannot tell you how many times I have said that incorrectly throughout those proceedings. So just note that change. Now, once that petition is filed, the time starts ticking. There are very strict quick deadlines under 202C. So once the petition is filed under 202C, an adversarial evidentiary hearing must be scheduled and held within 20 days, excluding weekends and holidays, of the filing of that petition. So the clock starts with the petition. During those 20 days, several things need to be completed. Discovery has to be provided by the Commonwealth to Respondents' Counsel, and witnesses have to be lined up. The evidentiary hearing has to be ready to go within 20 days. Now, importantly, this will differ down the road, but the respondent can stipulate to potential guilt and waive the evidentiary hearing. This stipulation cannot be used against the respondent in further criminal or civil proceedings. The purpose of the evidentiary hearing is to really examine that charged defense that brings them under 202C to begin with. So the purpose is to determine whether or not there's sufficient evidence to show that the respondent is guilty of the charged crime. If we're still talking about a prior defendant who was charged with murder, the Commonwealth has the responsibility of proving that murder that brought them under 202C. The burden on the Commonwealth at this stage at the evidentiary hearing is preponderance of the evidence. These hearings are held before a judge without a jury. There is not an option for a jury at this point, and the rules of evidence do apply. The respondent has the opportunity to present evidence of affirmative defenses that could be raised at a criminal trial on the charged crime. The Commonwealth does not have the burden of disproving affirmative defenses, and the respondent must prove an affirmative defense by preponderance of the evidence. So what this looks like for the evidentiary hearing, going back to an individual who was originally charged with murder, it looks very similar to a criminal trial that would ordinarily occur. The rules of evidence apply, so you have to prove the chain of custody for any evidence. If there's a victim in that case and the victim can testify, they'll be called to testify. Detectives will be called, individuals from the lab, and then the respondent and counsel will have an opportunity to cross-examine those witnesses and present proof as well. So the evidentiary hearing is very similar to a typical criminal trial. Now, at the conclusion, if the court determines that sufficient evidence has been presented to support a finding that the respondent is guilty of the charged crime, we then proceed to the commitment hearing. And the court must schedule the commitment hearing within 20 days again, so the same timeline, excluding weekends and holidays. Within that 20-day period from the evidentiary hearing to the commitment hearing, an examination has to be conducted or evaluation of the respondent. So 2 qualified mental health professionals, at least one of whom is a physician, must then meet with the respondent, form an opinion as to whether or not that respondent meets the criteria for involuntary commitment, and then generate a report and submit that to the court. That report is then disseminated to the parties that are involved as well. So, and that report has to be submitted 7 days prior to the commitment hearing. So if you're still following with me, you have an evidentiary hearing, and then about 13 days later, that report has to be completed. So the mental health professionals have a tight timeline to get these evaluations completed and their reports submitted. And then 7 days later, the commitment hearing must be held. Now, by 2 qualified mental health professionals, what that looks like in practice is you're talking about a psychologist and a psychiatrist. So you'll have at least one physician, a psychiatrist, and then a psychologist as well typically will be assigned. I know there is at least one court that has in their order stipulated that the 2 evaluators need to both be psychiatrists. Now, notably, if following the evidentiary hearing, the court determines that insufficient evidence has been presented to support the finding that the respondent committed the charged crime by preponderance of the evidence, the court must order the immediate release of the respondent. There is no discretion here. Now, at the commitment hearing, the Commonwealth, again, has the burden of presenting evidence, but this time, as opposed to proving the offense, we must prove the criteria for involuntary commitment under KRS 202C.050. Again, at this commitment hearing, the respondent and their guardian ad litem have an opportunity to testify, present evidence, and cross-examine any witnesses. Once again, the rules of evidence apply. And here, though, the standard of proof is beyond a reasonable doubt. So we've gone from preponderance of the evidence at the evidentiary hearing to beyond a reasonable doubt at the commitment hearing. Here, the proceedings shall be heard by a judge unless a party or the guardian ad litem requests a jury. So at the commitment hearing stage, there is the option for the proceeding to occur before a jury, which is not available at the evidentiary hearing. Also, it differs because the commitment hearing shall not be waived. So these commitments hearings must occur. Now, the criteria for involuntary commitment are contained in 202C.050. When this was initially enacted in 2021, all 4 criteria had to be proven in order for involuntary commitment to occur. The or that is highlighted on the slide was initially an and, so it was mandatory for all 4. This statute was amended effective July 15th of last year of 2024 to change that and to an or. So currently, only one of the 4 criteria outlined must be proven beyond a reasonable doubt to substantiate involuntary commitment under 202C. So the criteria here are A, we've got the respondent presents a danger to self or others as a result of his or her mental condition, or B, the respondent needs care, training, or treatment in order to mitigate or prevent substantial physical harm to self or others, or C, the respondent has a demonstrated history or recent manifestation of criminal behavior that has endangered or caused injury to others, or has a substantial history of involuntary hospitalizations under 202A or 202B prior to the commission of the charged crime, or finally, the 4th potential criteria is a less restrictive alternative mode of treatment would endanger the safety of the respondent or others. So I'd like to draw your attention to criteria C. Here it mentions chapters 202A or 202B, which we discussed earlier. Those prior involuntary hospitalizations can trigger one of the criteria. Additionally, the recent manifestation language that's highlighted on the slide, that was not originally included in the criteria in 2021. That was one of the amendments that was effective last July. If following the commitment hearing, the court finds that sufficient evidence has been presented that beyond a reasonable doubt at least one of these criteria have been met, the court shall involuntarily order that the respondent be involuntarily committed, and the cabinet is required to place the respondent in a forensic psychiatric facility designated by the secretary. In Kentucky, currently, we have one forensic psychiatric facility, that is Kentucky Correctional Psychiatric Center, or KCPC as we typically refer to it, and that's on the grounds of Luther Luckett Correctional Complex. Now, that's not the end of the inquiry. So we've had the evidentiary hearing, we've had the commitment hearing. We don't just say this person's been involuntarily committed and not look any further. There is a very strict schedule set forth in the statute for review hearings just to make sure that that continues to remain the appropriate placement for the respondent. However, 202C.060 subsection 1B does provide another mechanism for review. So if at any point during the respondent's placement at a forensic psychiatric facility, it appears that the respondent no longer meets that criteria because there's either been a material change in circumstance or new evidence to present, then the respondent or the respondent's guardian ad litem has the option of requesting a review hearing. So this is permissive, it's not mandatory like the other review hearings are. But so if, for instance, there's a material change in circumstances, the respondent is improving with treatment at KCPC, no longer suffering as severely from the mental illness, that could potentially trigger a review hearing. Or if, let's say, exculpatory evidence comes to light for the initial crime that they were charged with committing, then a review hearing could be triggered as well. The schedule for the review hearings is set out in 202C.060 subsection 2. I'm not going to go through each and every one of them, but from the legislation, it's a graduated schedule. So after the initial commitment review hearing, then another standard review hearing has to be scheduled between 90 and 120 days later, so essentially 3 to 4 months later. Then that bumps out to between 180 days and 210 days between hearings, and then it bumps out to once every year, and then you have a heightened review hearing every 5 years. So you see both the language of standard review hearing and heightened review hearing in the statute. Standard review hearings can be more informal. They could even be conducted at KCPC and at whatever setting is least damaging for the respondent. heightened review hearings have to occur in the courtroom. The respondent has to be physically in the courtroom, and the mental health providers that are conducting the evaluations have to provide live testimony. Again, these review hearings, the respondent does not have the option to waive them, so they must occur. Just as with the initial commitment hearing, the 2 qualified mental health professionals must conduct an examination of the respondent, at least one of whom is a physician. These reports must once again be submitted at least 7 days prior to the review hearing. At the commitment review hearings, the burden remains with the Commonwealth Attorney's Office in that jurisdiction to continue to appear at these 202C proceedings and to ensure that, to prove that the criteria for involuntary commitment continues to be met. Additionally, the Commonwealth Attorney's Office has the burden at this stage of illustrating that the respondent remains incompetent to stand trial as well. At these review hearings, the respondent and their guardian ad litem once again has the opportunity to present evidence and to cross-examine any witnesses. The criteria remains the same as in the initial commitment hearing. It does not differ. At these review hearings, the rules of evidence still apply. So while the standard review hearings can be more informal in a more informal setting, we are still bound to follow the rules of evidence at these review hearings, and the standard of proof is still beyond a reasonable doubt. Now, these review hearings can be heard by a judge without a jury, except that a respondent shall be entitled to a jury upon request if they've not had a review hearing with a jury during the preceding 12 months. So a respondent can ask for a review hearing before a jury as opposed to a judge, basically once a year. However, what we have learned as the statute has been implemented and individuals are practicing within it is if you have a respondent, let's go back to someone who committed an offense of murder. If they had their commitment hearing before a jury and then they're entitled to a review hearing 90 to 120 days later, so 3 to 4 months later, they can once again at that time request a jury. So they can have a commitment review hearing in front of a jury twice in the span of 3 to 4 months. At the conclusion of each of the standard review hearings, the court once again makes written findings of fact concerning whether or not the criteria for involuntary commitment under 202C continue to be satisfied based upon proof beyond a reasonable doubt. If the court makes that finding and the Commonwealth has presented sufficient proof, the court must enter an order authorizing the continued care and treatment of the respondent at a forensic psychiatric facility. However, if the court does not make this finding and the requisite proof has not been presented, the court must enter an order requiring the respondent to be discharged. So if you have someone who has been going through 202C for a number of years and that criteria at a subsequent hearing is not met, they must be immediately discharged from the forensic psychiatric facility. And these review hearings continue to occur per the statute as long as an individual continues to meet the criteria for involuntary commitment. So that's just a general overview of the process. I'm happy to take any questions at this time, and if not, if you would rather wait and hear from the Honorable Judge Jones, that works as well.
You can proceed, Judge. Thank you.
Thank you. So Ms. Dallum's done an excellent job of providing you with an overview of 202C as it's currently written in Kentucky law, and I'm grateful for the opportunity to continue the conversation, outlining judicial considerations around the involuntary commitment process for individuals who are charged with a qualifying offense. So thank you, Chairs Elliott and Storm, for the opportunity. As Ms. Dallum explained, prior to April 1st, 2021, criminal defendants who were found incompetent to stand trial were subject to involuntary commitment, under 202A. However, KRS 202A, as she explained, contains a provision that a mentally ill person may only be involuntarily hospitalized if he or she can reasonably benefit from treatment. This presented a perceived loophole in the statutes when an incompetent defendant cannot reasonably benefit from treatment. KRS Chapter 202A would not then allow for involuntary hospitalization. After an incident in which an individual allegedly committed crimes after being released from a psychiatric hospital due to this inability to benefit from treatment, The General Assembly enacted House Bill 310 during the 2021 General Legislative Session, creating KRS 202C. 202C has had one change since its original passage in 2021, and that occurred under House Bill 5 last year. That change directly impacted the eligibility criteria for commitment. At the Judiciary, we've had 4 years now to implement 202C across the state. Since then, there have been 34 commitments to the Kentucky Correctional Psychiatric Center under 202C. 20 of those patients have been discharged. 14 remain committed. 2 of the discharged have been brought back, re-indicted on their initial charges. And of those 34 cases, speaking from an appellate judge standpoint, opinions have been rendered, I believe, in 2 cases that were brought before us on appeal, and there are still 13 appeals pending of those 34. So some considerations that have been brought to the court's attention based on those appeals around 202C include timeline challenges. The statutory deadlines for hearings and discovery, they can be difficult to meet in practice, and which can place a strain upon the courts, upon the evaluators, and upon the parties involved. There's a GAL requirement. A guardian ad litem or a GAL must be appointed before the evidentiary hearing, but the GAL doesn't participate in the proceedings until the subsequent commitment hearing. So this can create procedural confusion and inefficiency. Additionally, there appears to be a lack of clarity on what the role of the GAL is, whether they're acting in the best interest of the respondent or whether they're acting as a neutral party, as a friend of the court. There's also a question that's left vague in the statute over who pays for the GAL and how much does the GAL get paid. There's also a burden of proof issue. The evidentiary hearing uses a preponderance of evidence standard rather than the beyond a reasonable doubt that we typically think of in a criminal trial. And there's disagreement on what the burden of proof should be. There's also criminal defendants or respondents are allowed to use the insanity defense during the commitment hearing, and that appears to conflict with the intent of 202C, which is not centered on criminal culpability, but on public safety and treatment. There's also lack of a clear appellate process. There's not a clearly defined appellate procedure or timeline, and several of these cases, as I've explained, have moved on to the higher courts. There's also a lack of discharge planning contained in the statute. The statute lacks requirements or processes for discharge planning. As Ms. Dallum explained, if someone no longer meets the criteria to be committed under 202C, then they're immediately discharged. And there's no plan for how do we continue to make sure that they stay involved with treatment, that they stay involved with medication, that they stay competent and remain not a danger to the public or to themselves. Next. And just a brief comment on the previous statute that wasn't actually included on the statute. I'm currently the chair of the Juvenile Justice Work Group for the Kentucky Judicial Mental Health Commission, and there is no juvenile competency statute. So regards to whether 202C applies to juveniles or how it would apply, or what we do with juveniles who are incompetent, there are no laws on that in Kentucky at the moment, something that we hope to remedy at some point. The Kentucky Judicial Commission on Mental Health is a multidisciplinary body established by the Kentucky Supreme Court to improve how courts respond to individuals with mental health needs and substance abuse and use disorders, intellectual and developmental disabilities. The Commission brings together diverse voices such as judges, court staff, treatment providers, professionals, community partners, religious partners, and even legislators, to improve our court system and how it responds to individuals with mental health and substance use needs. The Commission operates through 10 specialized work groups. Each work group is focused on a specific area impacting Kentucky's courts and communities. And these work groups foster open discussion. They identify challenges, and they help us develop strategies to strengthen connections between the justice system and our behavioral health resources so that we can make sure that people involved in the justice system who have mental health issues are able to obtain the resources and the treatment that they need. That also improves their outcomes. It improves the outcomes for the community and the safety of the community as well. More than 400 Kentuckians actively participate in these collaborative efforts. And while statutory change is sometimes part of the solution, our primary focus is on practical improvements that enhance court processes, expand access to treatment, and promote safety and fairness. The Mental Health Commission has proposed bench cards and provided those to judges to help them outline these processes so they know the best practices and how to approach someone that they believe might have a mental illness. It also has developed communication cards and things to help our providers engage in treatment, and also looked at every community and tried to identify resources that are statewide and are now trying to target resources available in individual communities. So if someone has needs, we know how to refer them to the best help available. One area currently under review is the 202C process. And to better understand its challenges, the Commission has convened a dedicated focus group to examine the issues that have been raised by judges and by our court partners. This group will continue exploring options and engaging stakeholders to identify meaningful and workable solutions. So again, I thank you for the opportunity to share with you all today, and we welcome your questions and are grateful for your continued support.
Well, thank you very much for the informative presentation, Ms. Dallum and Judge Jones. There is some discussion. Senator Carroll.
Thank you, Mr. Chairman. And Judge, you answered the question I had. Was looking at the numbers. However, I missed of those 20 that have been discharged, how many of them have reoffended?
2, I have been told, have gone back through the process. So when a case is under 202C, the charges are dismissed without prejudice, and therefore if the person can be brought back on those charges.
Okay. And are you all working on draft language for the next session to clean this?
We have, that's the purpose of the focus group, is to try and help identify language, and we welcome the participation of any legislators who want to be on those committees.
Yeah, and as far as the language for juveniles, I have the juvenile mental health. I would be happy to look at adding that language to that bill.
Thank you. Appreciate it.
Thank you, Mr. Chairman.
Thank you very much. Senator Thomas.
Judge Jones, my question is for you. Anytime you're on this committee, there's always a danger that you get too far in the weeds from a legal standpoint. But I do want to ask you this question about KRS 202C. I noticed on page 4, I want to reference this for all the committee members. On page 4, I'm looking at the evidentiary hearing. And I'm going to begin by saying that we all know that the standard of proof for an insanity defense is clear and convincing evidence. You know, that's been sanctioned by the U.S. Supreme Court as the standard for one to prove non-guilt by asserting the insanity defense. I'm just curious, particularly when I look at the second slide on page 4, which says that the respondent must prove an affirmative defense by preponderance of the evidence. That seems to conflict with the burden of proof for proving insanity. I'm just wondering why that is the case. No, shouldn't that be clear and convincing evidence, the same as someone going to trial and saying I'm not guilty by virtue of insanity? The preponderance of the evidence standard seems to be a bit low given current jurisprudence.
And I think that's one of the issues that have come up during the focus group is that shifting standard of proof, that it is preponderance of the evidence for the guilt phase, and it is beyond a reasonable doubt for the commitment phase. And then when you allow things like the not guilty by reason of insanity defense, again, that creates confusion in what we should look at and what the standards should be. And I think it's just caused some confusion, some concern, just to make sure that it is judicially, jurisprudentially sound.
Representative Kulkarni.
Thank you, Chairman. Thank you all for this very informative informative presentation. This is an area of law I'm very unfamiliar with, so I appreciate the education. I had 2 questions for you, Ms. Dallum, and then one for you, Judge Jones. I had a question specifically related to the physicians and the evaluation process. So I wanted to check: is there a list or some statutory reference for these physicians in terms of, are they restricted to certain conditions that have been enumerated?
They are not. What is typically happening in practice is, prior to the commitment hearing, the respondents are housed in KCPC. Typically, there are psychiatrists and psychologists that are affiliated with KCPC who are conducting these evaluations.
And then my next question is there a process, whether in statute or in practice or policy, for evaluating and eliminating conflicts of interest between physicians and the people that they're evaluating?
So I am not aware of any process. I don't know if that would fall back upon their professional responsibilities and their ethics to then highlight that if there was some sort of conflict. But there's nothing set forth in the statute.
Okay. And then, thank you very much. And Judge Jones, you had mentioned one of the issues is timeline challenges in terms of how long these appeals are taking. So how long is it taking for an appeals process, a typical process right now?
I may pass that out for the appeals process.
Yeah, I think that's what you had mentioned in your slide.
I think the timelines are the ones contained in statute, where you have to do have the evidence provided within 7 days, and then the hearing has to be held within 20 days. And before I was on the Court of Appeals, I was a trial court judge for 20 years. So getting all your witnesses lined up, getting your evidence exchanged, getting test results if there's DNA results, that can take months, not days and not weeks. And so that can pose a challenge to try and get everything in line with the timelines created by the statute.
Thank you. Thank you, Chairman.
Thank you, Representative Dietz.
Thank you, Mr. Chairman. During the interim, I've been working on a statute. The bill drafter is here. We're going to meet afterwards on guardian ad litems. This keeps coming up over and over, which is the role of the guardian ad litem, fees for the guardian ad litem. But you had mentioned specifically the role of the GAL and similar to the friend of the court. So I know in a family case, a friend of the court can be an attorney, it can be a therapist, it can be a social worker, and then they testify. A guardian ad litem is an attorney that represents the best interests. So I guess I'd like to hear a little bit more from you on where you feel, I mean, if they have a defense attorney representing them and we're appointing a guardian ad litem, I can see where those could be, the attorney's going to represent what they want, the GAL is going to do what's in their best interest. So I just want to make sure I know what I'm hearing. So as we work on proposed legislation on cleaning up some of this GAL stuff, that we hit as much as we can in the different areas. So I don't know if you can expand on that a little bit on what you're seeing with that. And I don't know that I've ever heard of a friend of the court being appointed in these cases. So maybe I misunderstood that as well.
I think sometimes there's confusions among the guardian ad litems themselves, and the courts have noted this on the focus group as part of the concerns, is just what exactly is the role of the guardian ad litem. Sometimes guardian ad litems can act in a friend of a court role, kind of as that neutral party and just advising the court and giving, I've reviewed everything, I've spoken to everyone, and this is what I see. And other times they're acting in what is the best interest of the respondent. So just, I think people wanting clarification as to, in these cases, what are we expecting of the guardian ad litems? Are we expecting them to be neutral parties to advise the court, or are we expecting them to look out for and advocate for the respondent's best interests?
Please go ahead.
And as far as fee, you mentioned that, if I understand what you said, that it was silent on how they get paid. We did a little cleanup, I think, 2 sessions ago in another area that directed, I think, the Department of Finance to make the payment. So is that also what you're suggesting, is there just needs to be some directive in there on how a GAL is paid? Mm-hmm. Okay, thank you.
Thank you.
Thank you. Representative Burke.
Thank you all for this presentation, and it's been a pleasure to be involved in some of the meetings of the Judicial Commission. I've really learned a lot by tuning in and listening to some of those meetings. That's where this question comes from. So with KRS 202C 050, which is on page 10. I noticed that it's different from 202A and 202B, where the criteria for involuntary commitment is a 4-part that is and here we have a 4-part test that is or. And when I read this closely, I see Part C says the respondent has a demonstrated history of criminal behavior that's endangered or caused injury to other. That means that literally everyone who gets this far meets the criteria for commitment, because they wouldn't be in this court, in this proceeding, if they hadn't committed a qualifying crime. Is that right? Do I understand correctly that technically everybody could just be recommitted over and over because they did a violent crime?
And I think that is one area that the focus group is evaluating.
Okay.
It's an area of concern.
Do you have any suggestions been formulated yet as to how to ameliorate that circumstance? It doesn't seem like in practice, based on the numbers that were presented by the appellate judge, that that's what's happening. But as we get further and further away from the drafting, we know that the law morphs. Any suggestions?
Not at this time, but we are discussing those and have additional meetings scheduled to assess we've identified areas that may need to be addressed. What are the best ways to rectify any issues?
Thank you so much.
Very welcome.
Thank you very much. Representative Nemus.
Thank you. I would note that the changes to the law in 2021, it was an amendment to Representative Heveron's bill, I believe. It was my amendment. We worked on it with now Congressman Morgan McGarvey and State Representative Mackenzie Cantrell, along with the Department of Public Advocacy. So that was a well thought through. Want to be very clear: we don't commit anybody unless there's beyond a reasonable doubt. The preponderance of the evidence is a standard for earlier on, much like a pretrial type of thing. So you're not getting committed unless there's beyond a reasonable doubt. The second thing, with respect to what my friend Representative Burke just mentioned, it is a potential concern. But what we had there, and by the way, the 2021 change was made as a result of a guy named Cade Madden, who was raping and biting a bunch of people and continually got released from because he was insane, so he couldn't go to trial. But they were releasing him from the facility, so he was out recommitting over and over and over again, which is why Senator McGarvey and I got together to fix this. The most recent one, which was part of Representative Bauman's House Bill 5 last year, was a situation in Anchorage where a man had killed his parents, or his mom, maybe it was both parents, I don't recall, and all of his siblings were scared to death that he was about to get out because he was threatening to come after them as well. The fact that he wasn't convicted of a violent crime was about to get him released when everybody knew that he was in the category for which he should be institutionalized if he wasn't going to stand trial. So that's the reason that the and became an or. I think that was very responsible. We still have the discretion on the judges and the prosecutors to move forward against those types of persons, but we cannot make that an and, because sometimes, obviously, the person committed the first crime that they've ever committed, and if they are of the particular category, we don't want to have to wait till the second and third crime, especially when it's such of a violent nature as it was in the Anchorage situation. So those were good changes. Those were thoughtful changes. They were run through prosecutors and the Department of the Public Advocate, and so I think any effort to move back will be met with pretty strong resistance. Thank you, Mr. Chairman.
Thank you very much. And just one other point, I think that, as you pointed out, Ms. Dallum, the application of this statute is only to persons who are charged with very serious crimes.
That is correct.
And so, what's her last name? Ms. Mitchell, do you have anything? I think I may have skipped over you earlier, so you may have had some comments. Thank you. Well, thank you very much for being with us. It was very informative.
Mr. Chairman?
We appreciate it. Yes.
Mr. Chairman,
yes.
Sorry. Just one point, if I may.
Absolutely. Representative Petrie.
I just wanted to point out to the chairman that we have an excellent representative of the Attorney General's office that gave an excellent presentation. I so appreciate it. And the water in Todd County is good, isn't it?
It is.
Yeah,
It is.
very good. Thank you, Mr. Chairman.
Thank you.
Thank you very much. So the last item that we're going to take up is eminent domain, and Representative Ryan Bivens is here and has some guests, and I know he's also going to be joined by Representative Roberts to discuss this topic. So introduce yourselves and proceed when you want to.
Thank you, Mr. Chairman, members of the committee. My name is Ryan Bivens, representative of the 24th District, which includes Greene, Hart, and LaRue County. Going to come to you today and talk to you about eminent domain. I've got a couple of guests here with me. I'm going to let them speak and tell their story first, and then we'll kind of summarize at the end. So turn it over to Ms. Rebecca Steele. Push your button.
Hi, I'm Rebecca Steele. And I'm here to speak on behalf of my community, Bourbon County and beyond, and my family. I'm from a long line of farmers, actually founding farmers in California. I've spent half my life here in Kentucky. Eminent domain took land from my family in California, my great-grandparents actually. And there were times that my mother and grandparents had to live very frugally in the years when the crops were down. When the crops are up, that land is more valuable than the amount of money that's given for eminent domain. It's the future value of the land they're not compensated for, future income. It was not enough. My grandparents passed away when my mom was in her late 20s, and she had to sell more land due to inheritance taxes, and then we came here to Kentucky. And it was hard to find the property we wanted. We had to invest quite a bit in infrastructure, covered arenas, fencing, quite a bit. Could not find the property exactly how we needed it for the purposes of cattle and horses. My mother was put over $400,000 into the dam of her lake a couple years ago. She was looking at future income of maybe doing a wedding venue when we caught wind of the threat of eminent domain. She completely stopped spending because any improvements, we were not going to receive the value of that. Anybody who has sold farmland, I'm a real estate broker. People are surprised often that they're tobacco barns and such. The value is not in the building, it's in the value it brings for income. So our whole community, there was houses that had just gone on the market. They sat. Everybody was frozen. Your choices in life became, frozen. We needed more transparency as to what was going on. We needed to know if we were going to be compensated, that it was going to be fair and enough, because you can't just pick up your farm and move to the same thing. It's not that easy. My mom is 72 years old, and her whole life she has worked to keep this land that's been worked so hard on by my family and pass it on to the next generation. That's what she does. And we've invested quite a bit of money in I'm just going to give you some examples of dollar amounts recently in the last 2 years. It was $415,000 for the repair and the dam for our pond. Almost $300,000 in roofs the last 2 years, barns, shelters for horses, and the housing. And the last 2 years, we had to pause the fencing during the eminent domain threat, and that paused $440,000 that's in the last 2 years been completed. The fencing company has had work to do for the last 2 years. This doesn't include all of our expenses, of course, and employees and so on. So I'm asking that we please make eminent domain a last choice. It obviously affects future income. I didn't even get into the sentimental value of our land. My neighbors are farmers, and they're at the retirement age, and their life plan has been to work on that farm until they die. That's what their parents before them did on the same property. It's devastating. The idea of you're retiring and your land's going to be taken. What are you going to do? You're not going to move to the city if you're a farmer. It's a way of life. That's it. I appreciate you all hearing my story.
Thank you all for having me. My name is Ike Van Meter. I'm from Lexington, Kentucky. My family has a cattle farm in Bourbon County that we've had since the 50s. And then my dad, who passed away about 6 years ago, added on to it and doubled the size of it about 25 years ago when the land was for sale. He bought it at the asking price because he thought it was a good investment, and we've looked after it ever since. So a little history. In 2017, we got a call from a neighbor asking us to look into whether some rumors were true about, the condemnation or eminent domaining of around 2,500 acres for a proposed 10,000-foot runway in Bourbon County. And that was the first any of us had heard of this. So I don't know how long discussions had been held, behind closed doors. I don't know what parties were involved. Since then, we have collected information and found things out. But during that time, and up until today, I still don't know, and we've still never really gotten to the bottom of who the end benefactors would have been. We're always told it's secret. We were sworn to sign non-disclosure statements and so on and so forth. So, out of town, corporate, commercial clients are being part of the process, but the constituents, the landowners, and the people most affected are not part of any process. We learn about it when the first article is written in the paper with everybody else. Yet we own the assets that are wanted by private companies, and they're going to use the state in turn to get those assets for a certain price. Once the community found out about it, there was obviously a lot of uproar, and we held some get-togethers for the people that would be most directly affected by the project. And then once the local government in Bourbon County kind of saw the writing on the wall, it was turned away, and the judge executive, stopped it in its tracks, and we continued to go on about our lives. I would hear rumblings that things were happening, discussions were still being held in Frankfurt between parties. And then in 2023, we see it in a line item in the budget. Again, nobody has ever to this day ever approached me about buying my land for any dollar amount. Nobody with any power has ever spoken to me or any other landowner in that area. We don't have any information on, again, who these private, it was going to be a P3 partnership. We have no idea who the private partners were, right? We don't know who the end benefactor is of these projects. Yet we're taking land from citizens of this state, citizens of that county, and landowners of that county, taxpayers. It is my belief that this should be a more open process that should be open to the affected parties from the beginning. I think there should be requirements to strengthen and determine the real party of interest in these projects, whether it's a true public need or whether the end benefactor is a private company, because replacing private for private is not